Welcome, everyone. Thank you for joining us for the dispute resolution group meeting on ESG litigation. I'm Hannah. For those of you, so I see a lot of new faces on here today, and I don't think we'll have time today to go around the room. But I'm Hannah Shea with World Law Group, and I work with all of our practice and industry groups. And I did want to introduce a colleague of mine who has just joined World Law Group this week, Brooke, who is also on with us. Brooke, if you want to say hello.
Hello, everyone. So I'm onboarding and I will be the communications and marketing specialist. So today I will just be sitting in, learning from you people and enjoying. So thank you for having me.
Thanks, Brooke. Before we get started, before I hand it over to our group co-chair, if you guys wouldn't mind taking a moment, and if you need help doing this, you can just send me a chat message, renaming yourself to include your firm name, which you can do by hovering over your video and clicking on the three dots in the upper right-hand corner, or finding your name in the participants list and selecting the More drop-down. And in both of those places, you will find a rename option. Like I said, if you have issues finding that, feel free to send me a chat. And as always, when we do have Q&A, if we do have time for that at the end, you can use the raise hand feature so that we can see that you have a question. With that, I'm going to go ahead and hand it over to our EMEA co-chair for the dispute resolution group, Philip Dickerman.
Thank you very much. Hello to everybody, and my only task today is to introduce our panel for today's meeting. And I have asked everybody to briefly introduce himself. So the panel is Louis Martin O'Neill, Tequi Tiong, Bart Adrian from Netherlands, Emma Carr, and Gillian Griffith. So I would ask to start that with the introduction by Louis Martin. He is from Davies Law Firm in Montreal, Canada.
Yes, thank you, Philip. I'm Louis Martin O'Neill. I'm the what we call coordinator of the litigation group in Montreal. We don't have a head of litigation, so we're a bit of a socialist group. And my practice is like I do a broad number of or broad type of litigations. Anytime, like a lot of corporate litigation, M&A. I do a lot of securities, director duties, and restructuring, and that's the breadth of my practice. And I'm here with Bart Adrian at CMS, Gilly Griffith at ENS Africa, Tequi Tiong at Wong Partnership, and Emma Carr at Garlings. And today we're going to be talking to you about a topic which is on everybody's mind, which is essential and that we've been seeing on a number of occasions, and that we're seeing increasingly, which is all the litigations surrounding climate change, ESG matters, mostly focused on environment. ESG is obviously broader than that, but we have seen in many jurisdictions a broad number and broad type of litigations involving climate and ESG matters. And we thought that it might be a good idea for us to show you like what really is a sample of the type of litigations that we have seen. Obviously, from one jurisdiction to another, this will change, and like the basic, like the legal principles will be different, but there are a lot of common trends that we are seeing, and that's what we want to discuss today. And like we will need, and you will need to adapt those trends to the specific of your jurisdiction's legal regime. But really what we see is people like plaintiffs are borrowing from like one idea from one jurisdiction and trying to apply to the other. So the issue is how can we learn from that, and how can we make sure that our clients are prepared to deal with these type of issues. And increasingly, I think this is not going to go away. Obviously, climate change is a highly significant matter, and that's going to be part of our life. And how to deal with that and how to deal with the claims is really the topic of today. So I'm going to share my screen and show you a PowerPoint that we've prepared really just to assist in the discussion. You guys are seeing it? I assume it's a resounding yes?
We do. Sorry, I was on mute.
No
Do you
problem.
have, is this in PDF?
It's in PDF.
Right.
And I will, hopefully that should work now. Okay. So,
Wonderful.
and I'll circulate it. We'll circulate it after so that everybody can access it. So, as I mentioned, climate litigation is a global trend, and Bart had prepared this this very interesting slide showing the increase. That slide is dated 2022, but we have seen simply in Canada, I can tell you that every month brings a new type of climate related claim. And clearly that's a trend that we're seeing throughout. And what type of litigations and claims are we seeing? And that's going to be what we're going to be discussing today. Like they vary a lot, but it can be grouped, generally speaking, in the following categories. First of all, there's a number of public law related litigation, public law and constitutional litigation, mostly where plaintiffs will be suing governments, asking governments to take specific actions against climate change. We're going to deal with that later. There are also a number of private actions being taken by individuals against corporations, typically large emitters of carbon emitters. So energy is a big target you will see of these type of claims. We're also seeing a lot of consumer and regulatory actions being taken, either through class actions by consumers or by regulatory authorities, essentially asserting greenwashing, so misrepresentation of some sort. We're seeing similar trends in the shareholder sphere. There's also a lot of securities regulators have been very active, requiring that companies provide full disclosure or much more enhanced disclosure about their emissions, and cracking down on many companies essentially boasting that they were green while in effect they were not. That was not the case. We're seeing a lot of activism in that area as well that we're going to be discussing. We're seeing litigation in the insurance field as well as in the environmental sphere. And we're going to start with the public law and constitutional claims. And Jill is going to be, Tekwi is actually going to be talking about these.
Yeah, hi everyone. Welcome to today's session. Happy to kick off the types of climate litigation that we're talking about. Louis-Martin had previously given everyone an overview of the different types of climate litigation claims that we'll be talking about today. So I'll be talking a little bit about public law, constitutional type of claims.
And Tiong-Tek, since we kind of Louis-Martin started right away, can you also please introduce yourself a bit? What?
Sure.
I know that you're from Wong Partnership based in Singapore, but so what's your practice? And so to know a bit more, it's very helpful.
Sure. Sorry, I was a bit anxious to get on with it.
Not your fault at all.
Yeah, well, hi everyone again. My name is Tekwi. I'm a partner with Wong Partnership in Singapore. I co-head the firm's sustainability and responsible business practice, or firm's ESG practice. I'm also a partner with the firm's corporate and commercial disputes team. So the mainstay of my practice is in litigation, arbitration, investor-state arbitration. So obviously the intersection between the two, climate litigation, is of particular interest to me. Philip, is that okay?
Yeah, that's perfect.
Thank you. Well, anyway, so to jump back into this, I don't think it's too much to say that most of the climate litigation that we're seeing globally today stems from or are based on some sort of public law premise or some sort of constitutional premise or some sort of a human rights some sort of a human rights premise, right? I think that's really the bulk of the climate litigation that we're seeing in the world today. These types of litigation are also known as strategic litigation, meaning to say that the purpose of these sorts of litigation may not always be to, for example, seek to stop certain actions or to claim damages, but more often than not are to raise awareness of the underlying issues in terms of, say, maybe inadequate steps taken to combat climate change by governments. And a lot of times these sorts of actions are, shall we say, propelled by non-profit organizations, by environmental groups. One of the key proponents of climate litigation or using climate litigation to effect change in climate policies is, of course, Climate Earth. So we have set out in this slide, and I believe the next, some examples from the different jurisdictions where all of us come from, where these types of climate litigation has taken place. So in the interest of time, we'll just go, I'll talk about two cases. The first is on the previous slide. Sorry, Lou, nothing. I'm going to go out on a limb here and talk about the Minister for the Environment and Sharma, an Australian case. And the reason why this case sticks with me is because there was actually a first instance decision and then an appeal. And I had actually relied or cited the first instance decision in a similar talk that I was giving. And I remember 2 days before the talk, as I was updating the materials, the appeal decision came out and overturned the first instance decision. So in the first instance, the plaintiff was successful in arguing that the minister owed a certain duty of care to the citizens or the general population in terms of giving approvals for the development of climate unfriendly projects, which in this case was a coal mine. This was overturned on appeal, and the primary basis for the overturning on appeal was really that the minister belonged to the executive branch of the government, and the courts should not be in a position, or rather should not put fetters on how the executive branch of the government makes decisions, because that in turn could, outside the context of climate-related cases, that could actually have a legal precedential value as to how all executive actions of the government are viewed. So that was actually the primary basis on which the case in the Minister for Environment and Sharma was overturned eventually on appeal. The next one that I want to talk about is on the next slide, and that's in South Korea. So the case of Do Hyun Kim in South Korea, this is a fairly recent case, relatively speaking. Commenced in 2019, still ongoing. A case brought by essentially 19 high school students filing a complaint against the South Korean government in the South Korean Constitutional Court, arguing that the nation's climate change laws violates their rights, fundamental rights, including the right to life and, there's a typographical error, including the right to life and a clean environment. Now, this is very significant because I think this sort of marked one of the high points in climate awareness and activism in South Korea. South Korea is one of the jurisdictions in Asia where climate activism is more prevalent, and this particular case marks sort of one of the high watermarks of what climate activists in Asian jurisdictions can actually do. So I think that's all I have for this, and I'll pass it on to the next speaker.
Thank you, Tekui. And I think what I would add that in Canada, very recently, there's a case which, in a similar format, where many young activists file a complaint against the government, essentially based on, there is a Charter of Right in Canada, which is a Bill of Right, and I think many of you have some similar statutes or constitutional principles, asserting that the government's inaction was a violation of their right to, essentially a right to live, and to and that by its inaction, the basic claim was that by its inaction, the government was essentially putting their health in jeopardy, in which case that breached the right of life. And the court dismissed the claim, but left open the possibility that such a right, like the right to live, would be broad enough to encompass essentially the right to live in a healthy environment. So and it's first instance, so it's going to go up, and like it's this type of right that actually may ground or form the basis for other claims that we're going to see elsewhere, because the first question is on which basis can you claim like the right, which then is going to lead to a remedy. And that's going to lead us to the next like series of claims that we're seeing, or remedies, which are injunctive reliefs. And Bart, I'm going to ask you to talk first of all about you, and then about this type of claims.
Yes, thank you, Louis Martin. Hello all, I'm Bart Elian de Ruiter. I'm from the CMS Netherlands. I'm partner corporate litigation, and what we see now as market trend that corporate litigation also involves ESG litigation, because it's a strategic topic in the boardroom, also responsibility of the board of directors. So it's a hot topic, and I'm also a member of the ESG task force of CMS in Netherlands and also globally. And I also work on ESG related cases for on the defense side, I must say, or risk management side for multinationals. So I'm going to talk to you about injunctive relief, and that's the kind of type of claim what we see in the Netherlands. In the Netherlands is a really activistic climate with a lot of NGOs starting actions that is also finds its origin in the good class action climate in the Netherlands. We see a very optimistic climate with a lot of people demonstrating extinct rebellion. I don't know if you've seen those also on the other side of the oceans, but meetings of shareholders are being interrupted by all kind of activists, but that is not legally. I'm going to talk today about legal actions in injunctive relief, and one of the big cases here is the case of the Dutch Shell against Dutch Shell of Milieudefensie. That's the big NGO, and also Greenpeace is also closely connected to it. And this case finds its origin in an earlier case against the Dutch state, the so-called Urgenda case. And that case was also, Louis Martin, it's funny that you mentioned before, but that's also based on the infringement of human rights in combination with the Paris Climate Agreement, in which certain agreements were made with regard to reduction of emissions. And in connection to Article 2, the right to live, and Article 8, the right to family life, of the European Convention on Human Rights. And the Supreme Court in that case ruled that that the Dutch government was acting unlawfully by failing to pursue a more ambitious reduction of greenhouse gas emissions, and it must reduce gas emissions emitted in the Netherlands by at least 25% by the end of 2030, I must say. And this Urgenda case was used as crowbar for further climate change litigation throughout the world, but especially also in the Netherlands. And then it started against the Shell case, and Shell in May 2021. There was the landmark judgment we are referring to here. Then in that case, Shell was ordered by the District Court of The Hague to cut its global carbon emissions by 45% by the end of 2030. Compared with the 2019 levels. And this was the result of a collective action of Milieudefensie with 70,000 co-plaintiffs and 6 other organizations. And according to Milieudefensie, the company needs to contribute to prevention of dangerous climate change via the corporate policy it determines for its group and the entire value chain on basis of a duty of care. And this duty of care was based on human rights infringements, Article 2 and 8, just like the similar reasoning as with the Urgenda case I was referring to earlier, but also in combination with soft law instruments such as the UN Guiding Principles on Business and Human Rights. And on basis of that, UN principles, a company must reduce, has an obligation to reduce its own climate impact, but also with regard to its value chain, it needs to do its best endeavors to do so. Appeal is pending in this case, but we see from this case on all kind of litigation coming up to other multinationals in the Netherlands. The 30 big multinationals received demand letters with a similar reasoning as in this landmark judgment, that they need to reduce their carbon emissions, similar to Shell. Naming and shaming is part of this kind of litigation. So all the demand letters are publicly available, and the climate organizations are checking the climate plans as they are. And in this respect, also shareholder activism is relevant. Louis Martin, do you want me to mention that as well at this moment, or shall I pass to the next speaker?
I think you can briefly mention it, since it may be like we're mindful of the time. We have an hour. We're also mindful that there's a lot of materials to cover, and it may well be that we're going to be dealing with a portion of the presentation at the next meeting. And since shareholders activism is at the very end, why don't you mention, like, take a couple of minutes just to talk about it now?
A hot topic in the Dutch boardrooms and also European boardrooms is shareholder activism. And it's when the minority shareholders use their legal and strategic and public means to promote their interest in listed companies. And what we see as a trend is that NGOs buy shares in listed companies, and then via engagement of big investment and pension funds who are also investors, that they follow the route of those NGOs. And what we see is that that they can change the policy very good in big multinationals from within the companies. So what we see at Shell is that all pension funds follow the NGOs. Follow This is such an organization who does this. And you see that they really make a change. And now we see that development popping up everywhere throughout Europe. But and it's a very effective way to change behavior of companies. But that is what you want to do with injunctive relief, but also with shareholder activism. That the policy of the board is directed towards a more and less climate impact and more climate friendly approach.
Yes, and we'll see, like, we've tried to break them down by topics, but in many instances, their topics are essentially grouped together in claims. And like you won't see some, like, it's very common that you will see 2 or 3 of these topics essentially grouped into the same claim, which makes it, I think, quite interesting. So the other, or like, aside from injunctive relief, another trend that we're seeing are damage claims, essentially based on the environment. And I think one good example that we're seeing is Luciano Luia versus RWE in Germany. RWE is the largest German electricity producer. And Mr. Luia is a Peruvian farmer who lives in Peru. And he has a farm next to a glacier who is essentially melting. And he asserted a claim in Germany against RWE, asserting that because of its conduct, RWE was responsible in part, or in large part, at least in a tiny part, for the global warming. And that, because of its conduct, that resulted in a direct damages being suffered by him. And the damage being, because the glacier was melting, he had to incur significant costs to protect his farm by essentially doing trenches and building a wall and so forth and so on. And by his calculation, RWE is responsible for 0.47% of the worldwide global emissions. I don't know how we came to that calculation. Seems high to me that one single company would be, even if it's in Germany, would be responsible for all that. And he essentially said, well, you owe me 0.47% of my costs. because you're responsible for that. And he asserted claims based on the German Civil Code, which we see in in the civil jurisdictions, you would see essentially claims. Well, there's an obligation for you not to not to act in a way which is going to create damages to your neighbors. It's a good neighborhood obligation, and there are many ways to articulate it, but at a high level, that's it. And the claim was dismissed at the trial court at a preliminary stage, but the Court of Appeal said that he actually had an arguable case. So the case is proceeding right now. It hasn't been tried on the merits. They're still in the process of discovery and preliminary matters. But based on what the Court of Appeal said, it does open the door to a claim of that nature. There are also similar claims being asserted in the US, and these claims would typically seek damages. It's always them, like they would often turn around damages being claimed for the cost incurred in order to adjust or adapt to climate change, and they're being focused on essentially on the issue, the emitters. It's probably more difficult, and Ryan, I don't want to put you under the spot. My sense is that it's typically more difficult in common law to make these type of claims because you need to you need to establish the existence of a duty, which is typically more difficult in common law. And Emma, you may, if you wanted to comment about this, feel free to do that. In civil law, it's typically easier, at least in my jurisdiction. You have a general duty to act in a way which is reasonable, or you have a general duty to act in a way which doesn't create harm to your neighbors. And it's a catch-all duty. So it's very flexible, and you don't have to really establish a clear and close connection between you and whoever suffers damage. Once you've established that you have not conducted yourself in accordance with what is expected from you as a reasonable person or a reasonable neighbor, then anybody who suffered foreseeable damages could in theory bring a claim against you. So I see these type of claims perhaps more easier to bring in civil law jurisdictions, but it may be that in the US or in the common law jurisdictions, it's also something that could be done. That brings us to the next topic, which is derivative actions against directors. And I'm going to ask Emma to talk about you and talk about this topic, which is very you'll see it's one of the it's clearly one of the type of claims being brought the more often, and there's a very recent discussion, very recent judgment about that, fresh hot of the press, that Emma is going to be talking to us about.
Thank you, and hi everyone. So as Leo Martin said, I'm Emma Carr. I'm a partner in our dispute resolution team at Gowling WLG. I act mainly for corporates as well as public sector clients in handling breach of contract and negligence claims. But I've also got a particular interest in ESG litigation as well as litigation funding of the same. So that's me. So derivative actions against directors. So aligned to the shareholder activism, which Bart Adrian touched upon, there's also a growing trend across a number of jurisdictions, really, for claimants to seek to incentivize the prioritization of climate-related issues by holding decision makers to account for their decisions, and by making them almost personally responsible for contributing or failing to adequately manage climate risk. So one particular and certainly novel way that we've very recently seen of this in the UK is the Clienter against Shell case, where the claimant in its capacity as a shareholder of Shell sought permission to use what's called the derivative claims procedure under the Companies Act in the UK to hold directors personally liable for failing to manage climate risk. So in Client Earth's own words, when it sent pre-action correspondence about the claim, it set it out as being and described it as being the first attempt to hold a company's board of directors personally liable for failing to properly prepare for the net zero transition. It represents a milestone in climate litigation, and company directors can and will be challenged to uphold their legal duties to manage climate risk by preparing their companies for the net zero transition. So that was kind of their starting point. In terms of the claim itself, Client Earth basically acquired just 27 shares in Shell, right? So this big global company just acquired 27 shares. But that gave them the standing as a shareholder to bring, subject to obtaining the court's permission, a derivative action against its directors. So as some of you may know, the derivative action process is subject to obtaining the court's permission to continue. But once you have that permission, the mechanism essentially allows shareholders, however minor, in this case just 27 shares, to bring a claim on behalf of the company against directors for negligence and or breach of their director duties. So in this case, Client Earth alleged that the Shell directors had breached their duty under the UK Companies Act to promote the success of the company, which is a duty that requires directors to have regard to a number of statutory factors, including the company's environmental impact. Okay, so Client Earth argued that the success of Shell was at serious risk from the climate change, and that their directors should have been doing more to transition away from fossil fuels. And by failing to do so, they breached their director duty to promote the success of the company. So Client Earth brought its application for permission to continue the derivative claim in February 2023, so just a couple of months ago. However, this was very recently, just last month, refused. The court actually found that Client Earth had failed to establish any prima facie case for breach of duty. And they also commented, albeit they were obiter, on the ulterior motives of Client Earth in bringing the action, being more to support their own policy agenda than because they were concerned about the success of Shell. Client Earth has, however, sought and obtained an oral hearing at the High Court to request reconsideration of that decision. So there is more to come on this. It's not the end. And as I said, this was the first time really the derivative claims process has been used in the UK to advance environmental aims. And although Client Earth has so far been unsuccessful in its claims, I think as alluded to before, there's obviously some advantage to parties, particularly environmental organisations, in bringing the claim in the first place in terms of the publicity it generates. You could even argue that the publicity generated in this case was a valuable victory in its own right, and that might well encourage others to do similar. So whilst this decision demonstrates the hurdles that activist environmental organisations will face in getting a derivative claim off the ground, we think it likely that this is only going to really represent a temporary reprieve for directors, rather than any real setback for those pursuing climate-related claims and seeking to hold directors to account.
Thank you, Emma. And to complete on that, what we're from Canada is essentially English-based jurisdiction. So from an English-based jurisdiction, your duties as director are essentially to act for the best interest of the company, and also to act in a manner which is in the same manner as a reasonable director would act in the circumstances with the duty of care. And on the fiduciary duty, there is throughout the world, there's a number of opinions that have been rendered as to what's the scope of directors' duties in those circumstances. The fiduciary duty is typically articulated not into a positive obligation. It's not you need to do this, this, and that, but you must act for what's in the best interest of the company, and it's defined by what it's not. Typically, the courts will intervene when you're not acting for the best interest of the company. But a number of statutes have been adopted, and the Supreme Court of Canada has said that the directors may, in fulfilling their duties, consider a number of factors. They're not obliged to, but they may. And those factors include the environment. And that has been codified in the Canada Business Corporation Act and in the provincial statutes. What we're also seeing is that, I think it's another impact of the Shell case, as a director, you don't like being sued. And also you want to show that you're doing everything, you're essentially following all the, like you're on top of your game, so to speak, and you're following all the best practices. But the more those best practices are going to be developed, and the more you're going to see companies developing policies in order to ensure that they're complying with like what one would call mainstream environmental obligations, the more you're going to create the baseline for what reasonable directors would be acting in those circumstances. So I agree with you, Emma, that the Shell case is probably the start, certainly not the end. And what is reasonable in the circumstances is going to evolve over time. And I don't think companies can be simply oblivious to what is being done and to like the increasing number of measures being taken by companies which are becoming mainstreams, because that's going to be the benchmark, and that's going to be the guideline in like in only a few years. So that's an evolving sector, and I think it's certainly something that directors, any board of directors, and Bart, you mentioned that, like in any advice we're giving to boards, irrespective of whether it's mandatory or not, you need to show that, like it's best practice to show that you have taken into account some, in some manner, climate obligation. Doesn't need, right now, you don't have to go out of your way and essentially make your company like just take environment into account, but it's not like you can simply shut this thought down and act as if you have no obligation. I think if acting in that manner becomes a risk, a liability risk down the road. That leads us to the next topic, which is consumer protection and greenwashing. And Gillian, I'm going to ask you to talk about you and talk about that topic.
Hi everybody, my name's Jilly. I'm an Australian solicitor, but I now live and work in Mauritius at ENS Africa. I mostly work in arbitration, but also general civil litigation. And so talking about greenwashing on the sort of consumer side and the regulatory side, we all have an idea, we know what greenwashing is, where there's an unsubstantiated claim or a misrepresentation that is made by a company to deceive a consumer into believing that the product or the service that's being offered is environmentally friendly or has a greater positive environmental impact than it might actually have. And this is coming up more and more now as consumers want to vote with their wallets and they want to choose products and services that have low environmental impacts. So for the consumer side, there are a lot of claims which are coming up that are seeking to protect consumers from these misleading claims and misrepresentations. There are some sectors where it's really clear where it could definitely come up, like O&G, energy, transport, mining, all those kinds of things. But you can also have greenwashing come up in any industry. So on the next slide, there's a case in the US talking about the settlement that arose between a group of different companies in relation to the plastic and the claims they made about them being recyclable. Louis Martin might want to speak more about that, but just to say that there's another case that was brought in the US against Coca-Cola and two other big producers of water bottles, Schwartz and Coca-Cola. That was last year only. It was an attempted class action where the defendants came under fire because they had promoted their products as being 100% recyclable. And the claimant said here that this was false and misleading because over 60 million plastic bottles end up in landfill every year or in incinerators. And so those materials are not actually reusable and recycled. And unlike with this case we've got here on the slide, the Schwartz and Coca-Cola class action was dismissed because here the court said that recyclable means only capable of being recycled and isn't a promise that something will be recycled. So I think it was, you know, an attempted kind of lobby suit to try and make some change and progress. It didn't quite get to where they wanted, but whether that had some publicity impacts would be interesting to know. It probably did. And there's another, I mean, in a completely different industry, in the agriculture industry over in Denmark, there was a case which is ongoing called Vegetarian Society of Denmark, pardon me, in Danish Crown, which is not in the slide. Apologies. So this is where 3 Danish NGOs filed a suit against Danish Crown, which is the, as I believe, largest pork producer in the EU. And they were claiming that Danish Crown was misleading consumers through a campaign that claimed that its pork production was climate controlled and the pork is more climate friendly than what you think. So this one's ongoing and it'll be interesting to see how that progresses. But just to say that consumer protection, greenwashing can come up in all kinds of places. And so to move on to the regulatory side of things, I'll speak mostly about Australia as that's what I know best. So in Australia in particular, there are 2 regulators. There's the ACCC, which is the Australian Competition and Consumer Commission. And then there's also ASIC, which is the Australian Securities and Investment Competition. So one is ACCC looking competition and consumer stuff, and ASIC is more company focused. Both of these regulators have said for 2023 that greenwashing is a priority focus that they want to be focusing on. And so from last July until this May already, ASIC has brought 35 different enforcement activities against various companies. One was ASIC and Mercer Superannuation. And that one was about misleading statements made in superannuation investments about sustainable nature and characteristics of the financial products offered. So there's really a growing interest in looking in the corporate side at funds and financial products that are being offered by companies, particularly with investors that are wanting to focus on, sustainable funds and these kinds of things, that companies really need to actually bring proof that what they're offering does match up to what they say they do. And just to talk quickly about the case of Plains Clan and Wonnarara people in Glencore, it's a complaint that was made to both of the Australian regulators about Glencore. So on Glencore's website, they made representations which have been said to be misleading or deceptive. So Glencore has been saying that it aims to be a net zero emissions company by 2050, says it's committed to aligning its targets with the Paris Agreement goals, working to a low carbon future, that its 2035 target is consistent with IPCC targets, and that it will responsibly reduce or deplete coal portfolio over time. So the complaint says that this is actually misleading or deceptive for a number of different factors, but some of them are that Glencore actually has no immediate plans to decarbonize, and actually it's expanding its coal operations in Australia. Also, Glencore's emissions don't seem to include some of its methane emissions. And so if they included the methane emissions, it would actually require Glencore to make greater cuts and have more interesting targets. And then also the complaint says that Glencore's net zero strategy isn't actually aligned with IPCC targets, because it's actually set out in the plan that there will be new coal production ongoing through this decade. So the complaint is still being investigated. But what's also interesting about this is that, so Glencore's parent company is Glencore PLC, domiciled and listed in the UK. And so one of our, favorite lobby groups, Client Earth, has also here made a complaint to the UK's Financial Conduct Authority and urged the ACCC, ASIC and the FCA to work together because there are sort of a broad range of issues that could be coming up in both jurisdictions. And that's all for me.
Sorry, I was on mute. Thank you, Gilly. And speaking of greenwashing, we're also seeing that in the security sphere. And Bart, it's now your turn again.
Yeah, what we see as a trend, because of in Europe at least, new regulations are coming up about publication in the annual accounts about how is your ESG policy, what's your climate impact, and what measures do you take? Do you have a climate plan? And the openness around that will result, according to Dutch legal literature, in a lot of claims for misleading annual accounts, misleading the investing public and so forth. So that's what they expect, and securities litigation on a bigger scale. And that's what they see as a market development here in the Netherlands. What will be the biggest growing market in the ESG litigation will be that companies need to report wider on ESG, and they try to pretend that they're greener than they are, because then they sell more to consumers, because the consumer preference is also changing. But if they're not, and most of them are not, then there will be lawsuits about financial greenwashing, so to say, greenwashing the investing public. And about what Gilly just told about greenwashing toward the consumer market, by way of an update, yesterday was a big case here in the courtroom next to our office here, the Court of Amsterdam, against Royal Dutch Airlines about their greenwashing towards the consumer, by saying that they are the greenest air company in the Netherlands, and that they fly green and carbon neutral, and that's apparently not true. And yesterday there was a big victory for them, because their claim was, the court said that the claimant was able to claim this, so the proceedings will continue, because KLM said we contest that they can represent this, that they have the representative power here to do so. But the court said it's a common, interesting, and an urgent instance thing, so you are capable of doing so. So that's an important victory, and we see on the social media, on LinkedIn and everything, we see this judgment coming up, that this is a victory for the activist parties and the NGOs, and this will lead to more claims in that respect. And to come back to the greenwashing.
So Bart,
Bart, can you explain what the request for reliefs are, which are being made in this claim? Are they seeking damage compensation, like a class action, or what are they looking at?
It's a principal judgment that they amend their policy, and that they rectify towards the market that they're not green.
Okay.
And that's what they're claiming. And maybe this is a first case, because if this is then won, you are a litigator yourself, then you have maybe a basis for a damage claim, because then all consumers will say, if I have known this, then I would not have flown with KLM. So you're right, that can result in damages claims later on. And here, all supervisory authorities, toward the consumer market, but also towards the financial market, have declared in their statements that greenwashing has a high focus of them. So they will focus on financial information and greenwashing, and consumer information and greenwashing. So, and we see a lot of activity there also from supervisory authorities. And if they see that a party is not acting in line with their obligations, then they will take action. And yeah, as you know, as you also see in competition law field, if they see if the infringement is found by supervisory authorities, then also other parties come to claim damages arising therefrom. So that is an interesting development. I don't know if you see that as well on the other side of the ocean, Louis Martin.
Yes, we're seeing both the securities regulators and like an increasing number of class actions being instituted on that basis. That's the new trend. We're also seeing, to go back to Jillian's earlier point, like we're defending clients in a copycat class actions relating to the allegedly recycled bags. That has percolated, but clearly the class action plaintiff bar has seen that as a new area to explore, and there's a number of these that we're seeing these days. We're also seeing short sellers using that, and it's typically like Spruce Point Capital is one of the leading, well, leading maybe not, but most active short sellers. We have acted for 2 clients who had issues with Spruce Point because they're very active now in Canada. They're essentially short selling Canadian stocks. And they've started to go also in the field of ESG. So they're essentially short sellers, as you probably all know, will bet that the stock of a specific company is gonna dive, and they actually do, like, they short sell the stock and then they publish a lengthy report essentially asserting that they've researched the company, and that based on their lengthy research, the company has done this, and that, and like has terrible accounting practices and so forth and so on, so that the price is way overstated. And it has resulted in like it's been successful in many instances. Now, what we're seeing, unfortunately, is that the mere fact that Spruce Point is publishing a report is starting, like, people just as a matter of knee-jerk reaction drop the stock, and that results in, like, very often essentially in the stock being depressed for quite a long period of time. But like the point here is that they're also going into disclosure, and like in the case of Oatly, they essentially attacked the way that they had described their ESG practice and their commitment. And Oatly is a brand which like was in part based on that. So I think it went to the basic of the reason why many investors wanted to be with Oatly and why many consumers wanted to buy Oatly products. So we're seeing that in short sellers. And going back to activism, Bart, you started to talk about it a little bit earlier, but why don't you continue here?
Yeah, I can say some short things about it, because I already told you about Shell case, which was started by activist action of combination of NGOs, and we see also a public tendency here that all people want to join NGOs and start to take action on it, also factual action next to legal action. So here in the Netherlands, roads are blocked. They go to shareholders meetings, and there they disrupt. For example, the last annual meeting of Shell in the Netherlands was also disrupted by contesters, especially Extinct Rebellion we see here actively, and also we see some protests on oil platforms and things like that here in the open waters. And that we also assisted some clients in that kind of in prevention and risk management in that kind of situations. So that's what we see. There's lots of activism, but also we see also that the consumer preference is changing towards more ESG friendly products and things like that. So we see that the change comes also from within. So activism is also at the consumer now. And we see activism in a courtroom, in the shareholder the dynamics, also in the consumer dynamics. So also the supervisory authorities. So the net, we say in the Netherlands, the net is closing. I don't know if it's a good translation in English, but the companies are in the corner of all kind of action, and that's ESG the will come and increase. Yesterday we had a big seminar for the insurance market, and the feedback from the insurance market participants was, yeah, but this is this is far from a bed show. They say it from this is not now. This is in the far future. But yeah, if the climate change evolves like it is now, it will become an urgent problem immediately, and then the activists will increase also significantly, because I was here with I had a seminar with the Children Investment Fund strategic director. They fund climate litigation all over the world, and he said that that we cannot meet the Paris Climate Agreement obligations anymore. So that means that there is dangerous warming of the earth, so that there will be very extreme impact within 5 years. So then everything will come to more activity. And like you just said before, we had this general meeting with all of us. Maybe Louis Martin, maybe you can tell about the climate change you are factually experiencing there, about the situation there, because that kind of developments also triggers more litigation from activist parties.
Yeah, I think we're referring to the forest fires that we're living right now. Like we have in Quebec, 7,000 people who just got evacuated, and because of forest fires, people got 7,000. Like there's a city of 7,000 people who got a notice at 9:30 p.m. that they needed to leave within the hour, and they had to do 5 hours of road to the next city. Yeah, we're seeing that. There are two last topics that we can, and we are, as litigators, we're good. It's like before the Court of Appeal, we have an hour and we're taking the hour, and that's it. Insurance, Bart, you want to speak briefly about that?
I can talk briefly about it. What you see now in the insurance market is that insurers are more hesitant to cover climate change related aspects. There's especially a big case about AEG that it refuses, that was in the United States, that it refused coverage for an oil and gas company for pollution and things like that, and climate change. So that's the development. What we see on that the insurance coverage is lacking in the near future for companies who are not ESG compliant.
Yeah, and we are also seeing environmental litigation in against specific projects. And Emma, can you talk to us about that briefly?
Yeah, I'll be very brief. I'm conscious of everyone's time, but I suppose it picks up on something Jilly mentioned before about the Glencore organisation and them going against Glencore PLC in the UK, even though the wrong didn't actually happen in the UK. So I think what we're seeing is a bit of a trend for the courts in some jurisdictions to become involved in claims arising out of environmental contamination, which occurs not just within their own jurisdiction, but all over the world. So in the UK, the courts have been willing to become involved in cases where the damages occurred elsewhere, but the claimant has been able to successfully argue that the UK courts should have jurisdiction because the polluter is controlled by a UK-based parent company. So I put down the case of Kiala and Shell. This is a very recent decision in the Supreme Court, perfect example of this. This particular case concerns the tort of nuisance in the context of a major oil spill, the Bonga spill, that affected land on the Nigerian coast, and a claim was brought against the Shell company, group of companies in England, which is where they were domiciled, for continuing nuisance on the basis that the claimants argued they'd failed to clear up the mess and it was a continuing nuisance, so they weren't statute barred, even though it was longer than the UK 6-year period. Now, the case didn't succeed on many levels, and not least the court was struggling with the concept of continuing nuisance and the limitation period. But I think what this case does show is that the scope for climate litigation really is widening, and I think hopefully you've got that from what everybody's said today. So in this instance, it's to include actions where the relevant events occur even outside of your own jurisdiction, but they can be somehow ascribed to the activities of a parent company domiciled within the jurisdiction, in this case, England. but it's really showing, I think Bart said about the net closing in, and that is the right expression, but also the net's widening in terms of where activists and where claimants are going now, and how they're trying to pursue it. So not just through different mechanisms, but even in different jurisdictions. Thank you.
So that's what we had. I hope it was interesting, and that it gave you some pointers as to where things are heading. I'm mindful of the time. We probably won't have time to field questions, but if you want to discuss afterwards, and send us an email, and we'll be happy to chat.
Yeah, thank you, everyone. Thanks for joining. I thought that was outlined really nicely, Louis Martin. So thanks for all of your work in organizing that. And of course, to everyone who presented with us today. But we are out of time. The recording for this will be on the website next week. If you want to share that with colleagues, and we'll of course circulate that to both the dispute resolution and ESG groups.